Good morning all. This morning we have a CMC hearing in a case of 030, a Court of First Instance case 2018. The claimant is Barclays Bank plc, the defendant Mr. Kapoor. Judicial Officer Maha AlMehairi is presiding. The claimant is represented by Evershed Sutherland LLP. Lead counsel is Jonathan Chu. Assisting is Rebecca Copley. The defendant is represented by Afridi and Angel Legal Consultants. Lead counsel is Shulak Shana Senanyaki. Assisting Nevan Bandara.
Your Honour, may it please the Court, this is a claim of guarantee for around £40 million. The parties are agreed on the directions to take in the CFC. What I had proposed to do, unless it was just the Court to do anything different, was not to delve into the depths of the case itself, but simply to take the Court through the agreed procedural timetable in order to set down these directions to trial. I don't know whether that would please the Court as a matter to proceed. That agreed timetable is in the bundle behind tab 8. Sorry, it's tab 6, I apologise. The first page is straightforward in the usual way. I would invite icon sentence word brackets to come out on the basis that this is now the Court making the order, so we don't need that. The list of issues is the standard direction. Over the page, then at 2 to 7, we have the production of documents timetable. The parties have agreed this timetable. Production to be by the end of August, replies within 14 days, and objections to any requests made by reply within 14 days, documents to produce in 14 days, that's 7. And then paragraphs 5 and 6 provide a procedure whereby objections to those requests to produce could be resolved by the Court in accordance with the relevant schedule provided for the rules. So that's production to be done. If there's no dispute by the end of September, if there is a dispute by October, that then leaves time for witness statements in December, 13th of December, that's paragraph 8. Reply 28 days later in January 19, and the usual directions to evidence in chief. The only expert issue, moving on to paragraph 11, the only expert issues are issues of UAE law, and the parties have agreed, of course subject to the Court's approval, to have written briefs by way of submission, so arguments by way of submission on UAE law, but for those briefs to be exchanged earlier in the process in order to ensure that the issues are properly joined, the parties can address any matters that would like to go to an argument. So that date is the 31st of January. And you see at A, B and C the 3 specific issues set out. So Article 106 and the demand itself, B, the effect of any breach of Article 106, and C, questions of determinations and matter review. The progress and monitoring date, 12/13, pre-trial review, trial bundles and reading list are all standard directions. I don't propose to take the Court through them other than just to know the date for lodging of trial bundles, 24th of March. At the moment, dates for skeleton and chronology are in for the start of April and for the end of March. Now, the parties have liaised between themselves to get dates to agree for the trial window, and the parties jointly would ask for a date in May, excluding May 6th to the 13th and the 27th to the 31st. So it struck me that it would be sensible to push the dates for skeleton arguments and chronologies back to 2 clear days before the start of the trial. and in 17 essentially to remove in paragraph 17 the words "and in any event by no later than 4 p.m. on Tuesday, 2nd April" for the claimant, and the equivalent wording "and in any event by no later than 4 p.m. on Wednesday, 3rd April" for the defendant, because we don't yet know when the trial is going to be. I've not had an opportunity to discuss that with my lovely friend, but I hope that's uncontroversial. And similarly, I would suggest that the parties prepare an agreed chronology to be filed a week before the start of the trial. So that's the timetable, that's the extent of the order the court's asking the parties to make today. I've deliberately focused on the procedural matters rather than anything else. I'm more than happy to take the court through anything else if that persists.
There's no need at this point.
I'm grateful.
So the trial date is, for the trial date, you are free in May?
Yes, so May, and then we have excluded dates, so not 6 to 13, and not 27 to 31.
Okay, we'll check the court's calendar and we'll liaise with the parties through email.
I'm grateful.
Okay?
Grateful.
Are there any other issues that should be dealt with?
Not from this side.
Thank you for your time.
If it may please Your Honour's Court, the defendant wishes to make a small submission. My learned friend was quite right in saying that the parties have agreed with the draft order which is to be issued by Your Honour's Court.
Yeah.
However, the draft order also requires the parties' agreement on the list of issues which has been set in the case memorandum before Your Honour's Court. Unfortunately, there is some areas of contention in the case memorandum, primarily arising out of the fact that, in the defendant's opinion, some of the matters that the claimant wishes to set down in the case memorandum appears to be controversial and may be considered to be not in compliance with the rules governing the case memorandum. However, I do not want to unduly take Your Honour's time on this issue. The defendant has tried for the past week to agree and come to a consensus, and the only matters in contention are those set out in square brackets in the case memorandum before Your Honour's Court. That is, in fact, the defendant's comment to Your Honour's Court, that the matters set out in the square brackets are not agreed between the parties. May I address Your Honour's Court on those issues, or would Your Honour prefer that parties submit any matters in writing?
You can address them and then send them in writing form.
So, first orally address and then in writing form, Your Honour?
Yeah.
Very well. Your Honour, as a matter of fact, even this morning I approached my learned friend and we made one concession, which I will not address Your Honour's Court. So the number of contentions in the case memorandum are now limited to just one issue in the way that the background is set out, which is paragraph 3, A3, the first page of the case memorandum, the last paragraph. Now, it is set out in square brackets that, according to the claimant, in early 2017, it came to light that the company's financial performance has deteriorated in 2016, and in April 2017, the company is defaulted under the facilities. Now, before I address this position, Your Honour may permit me to address Your Honour's Court on what the importance of a case memorandum is. A case memorandum is required by the court for the court's information to understand in the highest level possible what the case that the parties assert or what the case which is before Your Honour's Court is. Now, the case as far as the claimant is concerned was set out in the claimant's claim, and it boiled down to 4 matters. There had been facilities granted to the companies, in this case, the third-party borrower. There's apparently been a default under the facilities. There is a guarantee which the defendant has given, which is triggered by the default of the companies, and there is a certain sum due. Now, this was the only case advanced by the claimant in its claim. However, the defendant, in its defense, made a number of assertions which boil down to whether the underlying facility is in fact due to the principal borrower, because whether there is an obligation or amount due under the underlying facility is crucial when considering the present defendant's liability to the bank, and we raised this issue. Secondly, the defendant claimed that there has been a settlement agreement which was executed subsequent to the grant of the loan facilities, which had the effect of discharging the liability under the guarantee. This is another matter that was raised by the defendant. So, in effect, that is the case before Your Honour's court. However, in my humble opinion, it appears that the claimant is now, in the few points of contention before Your Honour's court in the case memorandum, trying to bring in a few preemptive arguments to the defendant's defense. And this is not something which is contemplated by the rules, Your Honour. The main words that are used in the rules, if I may quote them, in Rule 26.9 and 26.13, which describes what a case memorandum is, the words uncontroversial, fair, and balanced are used. Unfortunately, the manner in which the points of contention do not reflect this requirement which is imposed by the rules. For instance, Your Honour, as I was addressing Your Honour's court, in paragraph 3, the claimant is trying to state in the case memorandum that the company's financial position has deteriorated. Your Honour, this is a matter that has to be established by witness statements or at least by fact. There is nothing before Your Honour's court for the claimants to assert this in the case memorandum itself. And for this reason, the defendant humbly requests that this square bracketed submission, which the defendant feels is a preemptive submission containing the case memorandum against the rules, should be removed. Secondly, Your Honour, if Your Honour may turn to page 2 of the case memorandum, there is another square bracketed area. According to the claimant, having made a payment of $2 million under the settlement agreement, the company is defaulted on 1st September 2017. The settlement agreement became null and void on 30th September 2017, and the facilities remain in full force and effect. Your Honour, as I was saying, it is the defendant's position that the settlement agreement has a material bearing on this entire case. However, the claimant is now putting another preemptive argument to counter this position, and this is set out in the case memorandum. Your Honour, the defendant humbly feels that it is not unreasonable for the defendant to expect that the case memorandum is, as the rules say, uncontroversial, fair, and balanced. The defendant has not sought to keep any controversy in the case memorandum. The defendant is happy with how the case is presented, as long as it is what is required by Your Honour's court. Your Honour actually has more material before Your Honour, the claim, the defense, the reply, if Your Honour wants a more in-depth understanding of the case. So these sort of submissions, I believe, is not a matter which Your Honour's court should allow in a case memorandum, specifically looking at the overriding objective of Your Honour's court, which is to deal with disputes fairly and justly. So I request Your Honour to consider this as well. And moving on, Your Honour, in paragraph B4 of the statement, the claimant is trying to assert that the settlement agreement was signed by the defendant 3 times on behalf of each of the companies. Now, Your Honour, it was a crucial defense in the defendant's defense that the settlement agreement was never signed in his personal capacity by the defendant. Your Honour clearly sees the preemptive effort which the claimant is trying to assert in the case memorandum to counter this position. Your Honour, as a matter of fact, if it is the claimant's requirement to show that the settlement agreement was duly signed and executed, this matter is set out in B3 of the case memorandum. There is no requirement for the claimant to assert that the settlement agreement was signed specifically 3 times. It's a matter which can be gone into by the court at a later time. We believe this is another polarization of the case memorandum, Your Honour, and we request Your Honour not to not allow this in the case memorandum of the claimant. And finally, there is a contention as to one issue which the defendant wanted to put in, which is issue C4. Now, issue C4 is contingent upon issue C3. Issue C3 states whether any liability of the defendant under the guarantee is contingent on a determination of the amount of such liability. Issue C4 is, if the answer to issue 3 is yes, whether the DFC courts have jurisdiction to make such a determination. Now, the defendant is firm in its position that as far as this case goes, there is no jurisdictional challenge which the defendant wishes to bring as a primary issue. However, it is the defendant's position that the underlying liability, which is contingent upon the company's claim, if at all, against the claimant, is a matter that has to be determined if the amount of liability of the defendant is to be fully determined. Now, the companies are not before Your Honour's court, and for this reason, it is our contention that the DFC court may not be able to fully quantify the amount that is due from the defendant. And this is a crucial issue which is important for the defendant's case, and it is only reasonable that it is set out in the case memorandum, Your Honour. And as far as final contention between the parties, I will not take any more time of Your Honour's court, is the procedural history. There are a number of square bracketed comments on the procedural history. Now, Your Honour, the rules require the procedural history to be uncontroversial summary of the material procedural history. What is a procedural history, Your Honour? It is simply when the loan was granted, when the demand was made, when a legal notice was sent. But the claimant has sought in this procedural history to include matters as to when defaults occurred under the trade facility agreement. Your Honour, this is a matter in dispute. And more than that, it is not a matter that is uncontroversial and not a matter that should be set out in the procedural history. So for these reasons, we believe that the square bracketed areas set out in the case memorandum should not exist in a case memorandum governed by the existing rules of Your Honour's court. I thank you, Your Honour.
Thank you.
Your Honour, I'm slightly confused as to precisely what you're being asked to do here. The order that I took you through is forward-looking. The only relevance of the case management to the remainder of these proceedings is the list of issues, as my learned friend rightly said. That list of issues is agreed. So, in terms of progressing the case with case management, nothing needs to be done. The parties can prepare perfectly sensibly by reference to the list of issues. The rules don't say we need to prepare by reference to the case memorandum or by reference to the matters agreed. That's to help the court, to help you, Your Honour. You've had it now for the purposes of the CMC. It has either assisted you or it hasn't. We've been through the timetable, and these are matters that have already been gone. The list of issues is what matters, and the list of issues has been agreed. Prior to this hearing, those instructing me reached a position with those acting for the defendant that this document was filed with the square brackets in, essentially, as not agreed. There was no indication that any application was going to be made to strike these out, or that anything was going to be taken, but as far as I'm aware, that you were going to be asked as the court specifically to do anything. And that's absolutely the right position to take, because there is no need for you to do it. And what you're being asked to do, if I've understood the application properly, is to take a red pen to parts of a document that don't matter. That's a waste of the party's time, and it's a waste of the court's time. What actually matters is the list of issues, and that isn't in dispute. Now, I am perfectly happily in a position to go through each of the disputed matters, but my primary position is that it doesn't matter. I would just say two things about how it's structured. First of all is that a party can't make a matter that is uncontroversial controversial just by disagreeing with it. For instance, the defendant admits that he signed those agreements 3 times. The settlement agreement. The previous paragraph refers to the position vis-à-vis the companies. The subsequent paragraph refers to the position in respect of the defendant. And all that's admitted. So it's just a lawyer's tactic to say, well, we don't want that in. And because we don't want it in, it's therefore controversial and therefore it can't go in. It's just not how it works. Secondly, throughout, where these are matters that we, the claimant, accept, it has to be proved. We have said, according to the claimant. We're not trying to present to the court as agreed something that's not. We're being absolutely open in saying, this is what our position is, and we think it helps the court to know that at this stage. Now, as I say, I'm perfectly happy to go through line by line. I don't propose to, because you don't need to do anything to this document. We've got the list of issues. So, Your Honour, that's all I propose to say in respect to that. It shouldn't be wasting the court's time.
So I understand the list of issues is agreed between the parties.
Yes.
It's just the wording that is in the case memorandum. Yeah.
If I may address my learned friend on issue 4, there is a comment by the claimant that says that it is not an issue agreed by the claimant. So I fail to understand why the claimant is asserting that the issues are agreed when there is one specific issue that has not been. If my learned friend is agreeable to that issue, I do not wish to make further submissions.
Yeah, I mean, I'm happy to take that out, again, without prejudice to our point that it's not relevant, but that was so the court and the defendant understood our position on that. I'm happy for that to come out, and then we've got an agreed resolution.
Okay.
As far as the list of issues go, Your Honour, if that is the claimant's position, the defendant is agreeable as well.
Oh. Is there any issues you want to address?
No.
No?
Okay.
Thank you for your time.
Thank you, Your Honour.
All rise.